And if you want to give your phone number, do you want to give any of that
I
information?
actually don't know my own phone number.
Okay, well, you're like... Hi, everyone. You're watching the Light of Care podcast on YouTube or listening or watching us on Spotify. This podcast is about our company, FirstLight Home Care of San Francisco and the Peninsula. Our goal is to provide comfort, company, and respite care to elders in need. This podcast aims to educate seniors and their families about the resources and support available to help them live well and age with confidence. I'm your host, Lynn Carteris, and today we're joined by Roxanne T. Jen. She is an attorney at law, shareholder, and certified specialist in estate planning, trust, and probate law by the State Bar of California. With years of experience guiding families through the essential decisions, Roxanne helps people protect their assets, reduce stress, and ensure their wishes are honored. Welcome to the show, Roxanne.
Thank you. Thank you so much, Lynn. Thank you for having me
I'm so happy to have you here. We always start with background and what drew you to estate planning.
As a baby lawyer, I started my career like many other baby lawyers out of law school. You pass the bar exam. I was in Washington State, and I started practicing commercial litigation. So in a nutshell, it was really just representing small business owners to sue other small business owners.
Ooh, fun.
Yeah. Even
Or
if
not.
Nah, it was all right. A couple of clients actually asked me to help them with their succession planning, with their estate planning.
Oh, neat. Okay.
So I tried it.
Yeah.
I did it. And it was so nice because they're planning and they are doing something where they're planning for their loved ones. And after those initial experiences, I thought, I need to do this more. Gosh, it's been 15, 16 years now, and this is what I do, is estate planning and trust administration and probates.
How do you explain what an estate plan actually is and why everyone needs one?
The planning component is really important because while you have capacity, while you are living, while you still have the ability to make decisions about yourself, it's important to plan. And we need to plan not just for death. You know, my business partner and I joke around, and we always say, oh, what I do in our practice is we plan for death and taxes, which is true, right?
Yeah.
But we also plan for things that are going to happen where we have to make sure decisions are being made if we can't make our own decisions.
I would say most people really don't understand the process and how important it is to do early on, like you said, with capacity. But what is the biggest mistake you see people do when they're doing this?
The biggest mistake is just not starting, because once they're in the mind frame of starting the process, most clients will finish. The other mistake is folks might create an estate plan. For example, today I might create a beautiful estate plan, Lynn, and it's a revocable living trust, and I'm supposed to put my assets like my house in there, my financial accounts. So the law firm that I'm working with, like ours at McDowell Cotter, the law firm will help us transfer those hard assets, the real property assets, into the trust. But my homework is to go to the banks or those financial institutions and work on transferring those financial accounts. But if I forget, or if I don't make time to do it and I don't get it done, that's probably the second biggest mistake that we see, is just failure to fund an asset.
But I think that a lot of people confuse what wills and trusts are, and in the simplest terms that you can.
Oh, yes.
Try to explain the difference.
Most of our clients are coming to our office to create an estate plan that actually includes a revocable living trust.
Explain what that is.
Think
Most
of it-
people don't. Do you guys know what that is? No.
Think of it like as a basket. So I create this beautiful basket, right? I create a basket and it's a revocable living trust, which means that this basket can be updated while I'm alive. I can amend it. I can restate it. I can revoke it. I can put stuff into the basket. I can take stuff out of the basket.
What a great explanation.
Just a little basket,
Amazing.
right? So with that basket, assets can pass to the beneficiaries or my spouse without having to go through a process called probate.
Which is a nightmare.
It is a nightmare. And if I pass away with no estate plan, my stuff, my house, my financial assets, it all has to go through this court process called probate. So with a revocable living trust, if all of our things are in that beautiful woven basket, then assets will pass without going to the court system. However, if I die with no estate plan, the state of California gives me an estate plan, and the only place to use that estate plan is the probate court system. You can think of a will as a one-way train ticket to the probate court train station. Where do we go to get it checked off? Probate court. So if we have a will, whether it's a holographic will, which means it's handwritten, or if it's a formal will, which means it's, typed out, printed, signed, and witnessed, it has to go through the probate court system.
Why are powers of attorney and advanced healthcare directives so essential, especially for seniors or people with medical conditions?
Most people are going to live pretty long lives, but they might suffer a incapacity event. Like I might be diagnosed with Alzheimer's,
right.
Lewy body,
condition.
Parkinson's,
Yes.
or it just might be old age dementia.
Yeah.
Or I could be walking down El Camino. I mean, let's be real. I don't actually walk anywhere. I drive. But let's say I'm walking
Me too.
down. Okay,
Yeah.
See, same. So I'm walking down El Camino and I get hit by a car. Well, what if I'm in a coma, right? So we have those documents that you just named, the power of attorney for finances and the advanced healthcare directive. Those are for us to use if we're alive, but we cannot make our decisions for ourselves. Because if we don't have those documents in place that allow other people in our lives to make those healthcare or financial decisions, then we're going back to probate court under what's called a conservatorship process.
Right. There's a lot of blended families and second marriages or situations where family members don't all get along. How do you handle that?
Can I talk about the cabana boy?
You can talk about anything you want, girl.
I love it.
Go for it.
My example is my husband always dies first. All right, so boop.
Of course.
He's gone. He always dies first, all right? Sorry, babe.
The cabana boy's looking good.
Yeah, exactly. So I remarry. My husband dies. I remarry. I marry the cabana boy, and I have a daughter with the cabana boy. Well, now what?
Right.
I mean, I could have structured the estate plan with my husband so that everything came to me as the surviving spouse. Well, then I could split it 3 ways between the 3 kids. I could give everything to the daughter and the cabana boy. There's nothing that prevents me from doing that.
You can do whatever you want.
Right?
Whatever's
Exactly.
in writing. Yeah.
Exactly. So when we are planning for scenarios like that, not just with blended family when they're planning with us, but future blended family, we can actually account for situations where we're trying to protect assets for the benefit of the joint children.
You get a brother and a sister. Dad can't sign anymore. Mom's gone. And he says, I should do it. And she says, I should do it. Like, how do you handle that? It's a mess.
If we're talking to the parents way before they actually need this help, way before they have an incapacity event, then they can choose who they want to act on their behalf. They're making rational decisions. They're probably not being unduly influenced by any of the kids.
Of course not.
Right? Because if they're in a vulnerable situation where they're already starting to lose their memory, I mean, they're not incapacitated, but they're just not remembering things as easily. It's a lot more difficult for them to make decisions. So the earlier that client's plan, the better it is for them. And then they can name their loved ones, maybe their daughter first, their son second, their youngest son third. They can name in whatever order they want. And we actually really advise that they name people in their lives one at a time rather than acting together.
So how often do you think people should get their trust redone or updated or whatever?
I always advise clients to look at their estate planning documents every 3 to 5 years.
Okay, that's fair.
3 to 5 years just to see if it still reflects their wishes. Now, if it doesn't, then it's a good time to update. And that you could go many years without updating because if it continues to reflect your wishes, there's nothing that you need to change.
So for anybody that feels intimidated, overwhelmed, or like behind in getting this done, what's the very first step they can take to begin their planning journey?
Talk about it. It can be talking about it with your friends because we all talk about things that are important to us, to our friends, right? Talk about it with our parents. Now that we're going in the midst of the holidays, it's a great opportunity to talk to our parents about what they might have in place already. And if they don't have something, what they might need to have in place or even update, right? So just having the conversations with your loved ones and your friends and your your community is a great first start.
Tell us how listeners and viewers can find you.
You can be found at McDowell Cotter on Instagram.
We've got more interviews on the way. For now, a huge thank you to all my team for bringing this podcast to life. For more information, check out our website, thepeninsula.firstlighthomecare.com, and follow us on our social media pages. Don't forget to like and subscribe, and we'll see you next time.